Welcome to week 3 of the National Tribal Trial College Advanced Course in Tribal Court Legal Advocacy. We are going to be discussing utilizing expert witnesses in tribal court in order to be able to supercharge your trials and hearings. We are 60% of the way through the course. Woohoo, another couple weeks, and we're going to see you in Madison, Wisconsin. I can't wait to see you all again, my beloved students. We're going to jump right in. This is kind of a detailed, exciting, and extremely useful amount of information that we're going to be given over this week. So, all right, so without further ado, we're going to review the different types of witnesses that exist. Okay, so the most common type of witness is an eyewitness, also known as a fact witness, a precipient witness, or a lay witness. It's somebody who did something with their 5 senses. So they saw something, they smelled something, they heard something, and then they're going to come into court and they're going to testify about what they saw, heard, smell, experienced, felt, right? They're going to get on the stand and they're going to testify as an eyewitness or a fact witness. But that's the most common type of witness. Shirley would be a fact witness. Next door neighbor would be a fact witness. Cops would be fact witnesses. McDonald's managers, these will all be fact witnesses or eyewitnesses. Now, if you're a victim advocate, which many of you are, you may have been fact witnesses or eyewitnesses in tribal courts or in state courts or federal courts. And when you did testify, you testified about what you saw, heard, smelled, did or didn't do, right? Common things would be to testify about the photos that you took of a victim's injuries, or maybe you work at a shelter and you saw that the Shirley's parenting skills were exemplary, right? If that is an issue in the case, and you can testify about those kinds of things as the victim's advocate. However, I want to remind you that if you go to court and you've been the victim's advocate, you are waiving the victim advocate privilege. You open the door to the stall and the horse leaves, you can't get him back in, okay? So if you are going to be testifying in court and you have been the actual advocate for the victim, be careful. In Spanish, they say, no vale la pena. Is it worth the amount of pain that could happen, right? Is it worth it for you to testify, or is there some other way you could get that information into court? Now, if you're a police officer, you can also testify as an eyewitness. You know, when I arrived on the scene, what did I see? What did I smell? I smelled alcohol on his breath. I saw that her shirt was ripped, right? I saw injuries on the victim. So an officer could testify in a domestic violence case, divorce case, in civil court, or a criminal case. They could testify about all kinds of things that they saw, did, observed, smelled, didn't observe, those kinds of things. That would be eyewitness testimony. But this week we're talking about expert witnesses, and an expert witness very broadly is someone with greater knowledge than the average layperson about a topic, right? So who can be an expert witness? How do they get to be an expert witness? Why is their testimony helpful? This and more will be revealed during this lecture that we're diving right into right now. Okay. Rules, rules, rules. You got to know them, right? Your tribe may have rules on expert witnesses. Your state and your federal courts all have rules on who's an expert witness and how to qualify them. A lot of tribes use the FRE, the Federal Rules of Evidence, and they have adopted those about who's an expert, how do you use them, right? What kinds of things that they can testify on. So we're going to be talking about, there's kind of like 2 different schools of thought on expert witnesses. And so you got to find out, you are tasked with finding out how your tribal court rolls. Do they follow their own rules that are similar to the federal rules of evidence? Or are they following a different school of thought that we're going to jump into right now? Okay, the federal rules of evidence. I have found that in Indian country, this is the most popular or the most common way to be able to determine if someone is an expert witness and then what is it that they can testify about. So under the federal rules of evidence, if you have a person, right, who has specialized, look at me, I've highlighted them and made them bold on this PowerPoint so you can see what I believe is important. It's a person with specialized knowledge, skill, experience, training, or education that is greater than that of the average layperson or layman, right? And then we use these people with specialized knowledge, skill, experience, training, or education on a particular matter, such as domestic violence, right? We use them in legal cases to help the judge. So in a domestic violence protection order case or a divorce, child custody case, it's almost certainly going to be tried before a judge or a jury, let's say if it's a criminal case, that you call this expert witness in order to help the trier of fact, the judge or the jury, better understand some complicated issue that's involved in the case or to determine a fact in the case. And we're going to go through that. Why should you use an expert witness? Well, if you've got somebody in your community, let's say you've got an elder in your community who speaks the language and is like a ceremonial leader and is really beloved by all and everyone really respects them, and you can get them to come on the stand and talk about how domestic violence and violence against women is not a traditional value and women should never be sexually assaulted by their partners, and they get to determine when, where, and how they have sex, and that it's never appropriate to grab somebody's boobs in front of their kids or in front of company, and that's considered to be a form of spiritual abuse. You get somebody like that on the stand, right? And your judges are human. They see like, okay, you've got Clarice on the stand, and Clarice is like everybody's beloved grandma, and she's the bomb. That is going to kind of tip the scales a little bit in your favor. So that could be a reason why you would use Clarice or a tribal elder to talk about how domestic violence was traditionally handled, or how child custody was traditionally handled, or maybe you've got the head of a domestic violence shelter for your neighboring tribe. And it's somebody who speaks at all the conferences and is on all the national task forces and writes articles and stuff like that. They can explain to the judge things like the effects of domestic violence on children, or maybe that there's like escalating lethality risk factors. So surely really does need to have a protection order because things are getting crazy. Or it's not quote unquote mutual combat, like two dudes in a bar fight. You have to look at predominant aggressors. So you could maybe have a law enforcement witness or a domestic violence witness who's an expert, who's handled a lot of these cases, to talk about predominant aggressors. So their testimony can tip the scales and help you. It can be really helpful to have somebody testify on the effects of domestic violence on children in your child custody case, because sometimes it can be unclear. Like, why is Brian hating on Shirley? Why is he so angry? Why is he just like randomly attacking girls at school because he feels slighted because someone bumped into him, right? Why is that? Is that learned behavior? And what does that mean? Is there an expert that you could find that can talk about how children who are raised in domestic violence families where it's prevalent, that the boys have a higher risk of going on to be abusers and girls have a higher risk of going on to be victims? Could that be helpful to the judge in determining who gets custody? Maybe you could have an expert talk about Marvin's authoritarian disciplinarian parenting style in domestic violence and how that might affect the children. So this is basically, you get somebody on the stand who is respected and knowledgeable and has more experience and knowledge than the average person. It's going to help the judge or jury in a criminal case be able to understand certain facts or issues in the case. So I actually had a case before the Supreme Court where I was called as an expert witness, where the attorney in the trial court on a woman who was accused of murdering her abuser, the attorney never called an expert witness to explain the dynamics of domestic violence, right? So none of that came in, and the jury didn't understand why it was when he went and turned to lock the door, the front door from the inside, where he was the only one who had the key, why it was that she thought that she was in imminent danger of being beaten or stabbed or raped or possibly killed, right? Because they didn't have an expert witness. So you want to make sure on some of your more complicated cases, especially if your victim is facing criminal charges, that you dot your I's and cross your T's and you make it as easy as possible for the judge or jury to understand the dynamics, right? And I've listed a couple of different things that expert witnesses could testify in domestic violence cases. So like, let's say in a child protective services case, right? Or she's being charged with failure to protect her children. You could have an expert witness talk about why it is that she didn't leave, that staying with the abuser was more protective because he said he was going to kill her or the children. Leaving a domestic violence relationship or filing for a protection order or custody or divorce is the most dangerous time for women, right? So you can give the judge or jury a little bit more information to make things be a little bit more favorable and understandable on behalf of your client. Okay, now let's talk about the types of people who can qualify and testify as expert witnesses on domestic violence. So somebody who works at a domestic violence shelter or as a domestic violence advocate, they have more knowledge of domestic violence than the average person in your community. Maybe you are a lay legal advocate who works with domestic violence victims, such as all of you in this course, right? You could theoretically testify as an expert witness on domestic violence, not in your own case, but like maybe go to the tribe next door or in, right? And not on a case that you're on, but you could probably testify as an expert witness. Let's see, the Office on Violence Against Women funds you to do domestic violence work at the prosecutor's office or wherever it is that you're working, right? That might qualify you and help you qualify as a domestic violence expert. If you're a cop at a DV unit, if you're on the DV task force, the multidisciplinary team, the lethality review board, right? You're sitting on your tribal domestic violence code drafting committee, or you're the one who helps the court make layperson friendly forms pro se so victims can represent themselves. Or maybe you're helping to negotiate an intergovernmental agreement with the county sheriffs on responding to domestic violence, right? Maybe you present on domestic violence at tribal council meetings in schools or at the hospital, or you train at conferences, or you write articles on domestic violence for your newsletter or your tribal newspaper, or you are on your tribal radio station being interviewed or on TV, or maybe you've got some education like a AA degree or a master's degree or something where you've studied domestic violence. All of these things are factors that would enable this person to likely qualify as an expert witness in tribal court on domestic violence. So there are experts on domestic violence. We could get somebody who is an Anglo with a bunch of PhDs, has written a bunch of books, but are they an expert on domestic violence against American Indian and Alaska Native women? Well, I would submit that we might need that extra factor, that there is a different dynamic, in my opinion, as to how domestic violence is perpetrated, the dynamics of domestic violence and the responses in Indian country and in Alaska Native villages. So I found that a really good expert on domestic violence against Native American women would be somebody who lives in the same community and knows a lot about the culture, the language, the customs, your systems. Do law enforcement respond? Does it take them 2 days to respond, right? Or are they just Johnny on the spot? Are they working extensively in Native communities and training your community on domestic violence, and then maybe cross-training your allies off tribal lands on domestic violence, right? So most domestic violence advocates can qualify to be an expert witness. So I would say, not bragging or anything, but y'all gonna be bragging on this too, that if you've got victim advocate, who's worked at your shelter, does all the gorgeous and beautiful, helpful things that victim advocates do, you're going to be able to get that person on the stand and get them qualified as an advocate. We're going to work on this when we go on site. We're going to give you some skills right now, but if this domestic violence advocate or cop works with Native women, right, and they've gone to trainings, or they've done, they've conducted the trainings, they're a speaker, or they worked on codes, or they respond to, 50 domestic violence victims in the past year, right? All of those things add up. And that person can qualify as an expert witness, most likely in your tribal court. I'm going to keep saying this, making you paranoid. You're going to keep thinking about this. If you were the victim's advocate, okay, try not to testify on her behalf. If you possibly can get any of the information in through other witnesses, please do. What I recommend is that you form some kind of a cooperative alliance with another DV program so that you could be like, hey, I'm Ho-Chunk and I work at the Ho-Chunk DV program, but you know what, if we've got a Ho-Chunk victim and I'm gonna need to have an expert witness in this case, hey, Menominee, you wanna come on over here, right? And then you can be an expert witness on domestic violence against Native women and maybe not even ever meet Shirley. Don't ever meet the victim, right? And we'll just hand you a packet of information with the police reports and photos and the school suspension letter and show you the crazy McDonald's videos if we got them, right? I'm going to give you a packet of stuff, Menominee lady, and then you come into Ho-Chunk and we get you qualified as an expert. And you know what? I got your back. If you ever need an expert witness to testify about domestic violence, and you've worked with that victim, bring me in, right? I'm at Ho-Chunk, I'll be happy to do it for you. So I recommend that you do cooperatives on this, right? Don't testify in your own case, even though you probably are the most expert person in your community. All right, I told you there's two different ways of expert witness looking at them, right? As whether someone's an expert witness. This is the Federal Rules of Evidence, Rule 705B. You've got to disclose who the person is, who's the expert witness, and you've got to disclose the underlying facts that they use to form their opinion. So in our materials, we've got a whole bunch of information. We've got police reports and medical records, right? Theoretically, you could hand that whole packet to your expert witness and say, here you go, review this, and then I want you to base your opinion on what it is that you've read here. So maybe you don't even interview Shirley, you've never met her before. I just give you some documents and some items, you review it, and then we're gonna have you come into court. We're gonna try to get you to be qualified as an expert witness. Okay, so you're gonna have to disclose the facts or data that you've given to the expert that she relies on to form her opinion, okay? So, two standards for admission. If your tribe follows the federal rules of evidence, they likely follow something called Come Ho Tire. The rules set forth in Come Ho Tire, where the judge is the gatekeeper, and that your expert witness has to have specialized experience, knowledge, skill, training, or education. They have a couple of those factors too. They have to have relevant and reliable testimony, and the testimony has to assist or help the trier of fact, which is the judge or the jury, to determine a fact in issue. Such as an example would be, what are the effects of domestic violence on children, right? Could it be that Marvin's abusive authoritarian style and witnessing the violence causes Marcy to regress and start peeing in her bed again, right? Or causes or it's common that boys who see their fathers abuse their mothers will often identify with the father, and then they'll adopt abusive attitudes and behaviors towards females, right? So an expert witness would help the judge understand what is going on with these kids and why are they acting like this, right? Are they just like filthy and unkempt because Shirley's a bad mom, or do they exhibit a trauma response? And your expert can help your judge figure all of that out and hopefully tip the scales so that Shirley is the one who gets custody, okay? So if your tribe does not follow the federal rules of evidence and Come Ho Tire, then they follow something called the Fry test, like French fries at McDonald's test, right? This is a little bit, for me, I find this to be a little bit harder and a little bit more scientific, Anglo style, right? So under the Fry test from 1923, now Remember at the beginning I said, find out what your tribe follows. You're probably going to follow the Fry test that is based on this case called, they're probably going to follow the Kumho Tires case, which is based on the federal rules of evidence. Okay, I'm like 90% sure, but you don't know, man. It could be 10%. You could be one of those 10% outliers, in which case, I'm just going to mention this briefly. Under this non-federal rules of evidence test that maybe only a small portion of you guys are going to follow, you have to show whether the proposed expert witness testimony is sufficiently established to have gained general acceptance in the particular field to which it belongs. Okay, so then you have to spend a huge amount of time saying that domestic violence theory is not junk science, that it's legit, that like fancy people with degrees have studied it. There's like all these peer-reviewed journals and articles. It's a little bit of a pain in the butt, I have to say, to have to prove that up. So if your tribe, like probably I'm going to guess 90% of you follow the federal rules of evidence or model your rules of evidence like that, then you have to show that they have specialized knowledge, skill, education, right, greater than the average layperson. You don't have to spend too much time on the theory of domestic violence is legit, and we're not just a bunch of all man haters trying to like, right, get one over on Johnny Depp, right? That there actually is a social science that of domestic violence. And then we've got lots of smart people who write articles about that, right? So you're going to have to, if you're on this Fry test, that small percentage of you, you have to talk about domestic violence theory, which I think is a big pain. We're not going to go over it in great detail. If your tribe does follow Fry, let me know. I can try to give you some extra materials on the side. Okay, so basically, with this Fry test, you have to show that domestic violence theory is widely accepted. And you're going to have to like have your domestic violence witness be all egghead and fancy pants with like a fancy CV, and they're going to have to talk about, you know, domestic violence theory and power and control and all that kind of stuff. And I've listed some what courts considered to be like if these folks accept domestic violence theory, right, that, oh, it must be legit. If you've got social scientists and the federal government accepting it and all these law journals, then it must be not junk science. It's got to be real, and we got to sit up and listen to it. So if you can come up with like maybe like the Violence Against Women Act, right? The preamble to that talks about domestic violence, or your tribal domestic violence code. Sometimes the preamble or the introduction will say domestic violence is not traditional and it affects the health, safety, welfare of the tribe, right? It might have some things. You can look at publications by basically the more prestigious the organization to non-Indians, that's like federal and state courts, like so the American Bar Association, right, or the United States Department of Justice, or the National District Attorneys Association, any kind of publications like that that your expert would rely on, especially state and federal courts, they love that, right? Tribal court, if you've got, you know, Clarice or Elsie and they're like, you know, 87 years old and one of the last fluent speakers and they're beloved by all, you're not going to really need this, right? But if you're in a court where they go more on the science, right, then you're going to have to try to see if you can garner lists of important articles or publications or agencies that accept domestic violence, power and control theory as legit, right? Places that you can look for them are peer-reviewed journals. So law reviews, right? There's some law reviews, there are peer-reviewed journals, there's social sciences journals, right? I've listed a couple of journal articles that my experts have relied upon successfully, where the court has said, that's right, these are legit articles, this looks like science to me, right? If you've written anything that's in a peer-reviewed journal where other professionals have read your work, or your expert witness, by golly, bring a copy of that. And your expert witness, if you're in one of these Fry jurisdictions, right? Actually, if it's federal rules of evidence, Kumho, which is like 90% of you, where you just have to show you've got specialized knowledge greater than the average layperson, right? Still, you're going to have to disclose what it is that you reviewed, right? The police reports, the medical records, the videos, the letters from the school, that kind of stuff. And then if you have, like important domestic violence articles that you rely upon routinely, right? Bring a list of those also, because it's possible that someone could question you on that or question your witness on that. Even if you're in one of those FRE, come ho tires type of expert witness jurisdictions that most of you will be in. Other things that your expert witness can say that she relied upon in forming her opinion is learned treatises. So these are like textbooks. So one of the things you could do is, like, if you find really cool articles that you use in your work, right? Print out hard copies or get electronic copies and put them in a file. And you can generate a list of citations, or these are the kinds of treatises or peer-reviewed journals, right? Or findings of Congress in the Violence Against Women Act, or findings of your tribal council in your domestic violence code in the preamble, right? Bring those with you to court or have them available. Somebody somewhere might ask you about it. And believe me, it's really, really impressive if you're like, oh yeah, just one moment. And you flip to your book and then you go, oh yeah. I'd like to refer to Nancy Lemon's seminal learned treatise, the Domestic Violence Law, in chapter 16, page 387, right? Whoa, that just blows the roof off of the whole court, and people are really, really going to sit up and take notice. You don't have to do this. This is sort of like bonus extra fancy pants points. Most of you are going to be in this federal rules of evidence, come ho tire jurisdictions. And all you got to do is show you've got more knowledge than the average bear, right? You're smarter than the average bear about domestic violence, this expert witness, right? They have got training on it. They've worked in the area. They talk about it. They get funded for it, right? All kinds of things that other outside forces recognize them as an expert. Okay, let's go back to basics. To testify as an expert witness, their testimony must be based upon sufficient facts or data, the product of reliable principles and methods, and they must apply the principles and methods reliably to the facts of the case. What that means is that you gotta like connect the dots, right? You gotta, if you're using an expert witness, give them the pile of materials for them to review. Then they review it. And then they take all of their knowledge and experience working as a domestic violence expert, or they got a PhD in sociology, and they teach about domestic violence at the University of Wisconsin, or whatever it is that they do, right? That they've got a pile of materials that you gave them, that they reviewed them, and then they applied their knowledge to the facts that you gave them. Okay, so your experts should be using good, solid, widely accepted domestic violence theory. If they've got statistics that they're using, the majority of Native women have survived domestic and sexual violence in their lives, right? Those kinds of things. See if they can cite the source, or you can provide what the source of that is, right? And you want to, ask questions of the witness on the stand to show that domestic violence is not just some weird man-hating made-up thing, that there's a lot of people over the last, several decades who've written about it. There's funding streams based upon it. The Office on Violence Against Women was developed in response to it, right? So this is not something that you just made up. It's actually real. And then once again, watch out for confidentiality issues. Don't testify as an expert witness for your own victim. Get somebody else, preferably from a neighboring jurisdiction. Now, if you're an expert witness, they get to testify as to the ultimate issue in a case, right? In the civil case, they get to testify as to the ultimate issue in the case, such as who should get custody of the kids, who's the better parent, right? Should the court issue a domestic violence protection order? Who is the predominant aggressor, Marvin or Shirley in the trophy incident, right? And should she be charged with a crime? Your expert witness, once they're qualified, once you put them on the stand, and then you're able to show domestic violence theory, not a joke. This person really knows what they're talking about because of X, Y, and Z. You can ask the person, the expert witness, you can say to them in a custody case, if you've qualified them as an expert witness, do you have an opinion as to which parent would be the better parent for Marcy and Brian? And then they can say, I believe Shirley was. And then you can ask them why. Tell us exactly why you believe that. And then they can expound on that to the judge. It's really, especially if you've got somebody who is well liked by the judge or well known in your community, boy, is this an influencer and a game changer. So I really want you to consider using expert witnesses, really, really. And that's why I devoted this entire week to talking about using expert witnesses in your civil DV cases. Okay. What are the nuts and bolts of it? Okay, we know that expert witnesses can be helpful. They have to generally have greater knowledge than the average lay person on domestic violence based upon their work experience and living in the community and serving victims and education and the training they provide, all of those factors. But then, how do we actually get them into court? First of all, you have to disclose that you're going to be working with for the expert witness on domestic violence. You're going to have to give them their name, right, and their qualifications. So if they have a CV or resume, right, you're going to have to disclose that to the other side, and then you're going to have to subpoena them. So you go to the court and get the subpoena. Do that right away. Now the other side has the right to depose them, to have a deposition, or to interview them in a pretrial interview, which they may or may not exercise that, right? Sometimes you can have them stipulate to the qualifications of the expert witness and for their testimony to be considered as an expert witness. And we'll go through why or why not the other side might want to do that, right? And generally, you're going to have a hearing and it can be a standalone hearing, right? So you got your trial, right? But before your trial, you could have a standalone hearing, a pre-trial hearing, where the judge says, all right, you have the opportunity to put this witness on the stand. We're going to try to see if you can qualify them as an expert witness. And if you do, then we'll let you bring them to trial. Now, sometimes for reasons of time and cost, your judge might be like, all right, you disclose the expert witness. When it comes time to put them on the stand, it's just me, it's a judge bench trial. We'll see if you can qualify them right there at trial. Okay, it could be a little harrowing because you don't know if their testimony is going to be admitted or not. Probably. And then once you get somebody admitted once as an expert witness in that court, it is like pretty much slam dunk that you're going to keep getting that person again and again. The next case qualified as an expert witness. So if they don't do it at a pretrial hearing, it's a little bit scary because you're like flying by the seat of your pants at the actual trial, putting the person on the stand and going, please God, let them qualify. Let me be articulate and ask the right questions and have the judge, right, rule that they're an expert witness so that we can have them give their ultimate opinion on an issue in the case, such as who should have custody, whether Shirley should have alimony or spousal maintenance because of the years of abuse, right? A decade of abuse and what it's done to her, right? So we want to have expert witnesses help illuminate the issues, and they can even weigh in and give their opinion on the ultimate issues. And you can do that either pre-trial at a hearing, or if the judge says, nah, I'm good, we'll just do it the day of trial, right? When you get ready to put on direct, wake me up and I'll see if I can qualify them, right? Help you qualify for them. So you're going to be, when it's your expert witness, you're going to be qualifying them using direct examination, right? And then the other side, Marvin gets to cross-examine them. And then if something came up on cross, right, that was new or needed to be clarified, you could do redirect. Very, very infrequently will the judge allow Marvin to do recross, only if you've opened the door to a completely different universe that was not raised before. Happens rarely, but it's possible. All right. We're going to hope that the judge is going to allow you to have a pre-trial hearing, right, to qualify the expert witness. Sometimes that pre-trial hearing, I'm going to warn you, could be like, all right, your trial's at 10. Why don't you come in at 9? No pressure, right? For me, it's scary because, like, what happens if I don't get them qualified? Does that mean I have to, like, rethink my entire strategy of the case and then present it a completely different way? Yeah, it does mean that. But I've had really good luck with expert witnesses. And mostly it's just like getting all your ducks in a row, dotting your I's and crossing your T's. And then maybe, it's a Fred and Ginger dance move with your expert witness. You want to try to practice with your expert and make sure that, right, that they feel comfortable testifying. They know what's going to be coming up, right? So you have to disclose that you're using an expert witness, and you're going to have to subpoena that expert witness, and you're going to tell the expert witness everything that's going to happen, no surprises. I advise you to meet with the expert and then tell them about the key issues. You know what, expert witness, he's threatening to like kill her with medicine. Expert witness, we've got that in some police reports, right? Right, you've been the head of behavioral health here, and you're a ceremonial leader. Yeah, what do you got to say about that, right? What kind of person in our community is that? Somebody who is an honest person who engages in that kind of bad medicine, who's a good parent and the children should be raised by. So I'm going to be asking you about that, since you're an expert on, the culture and the customs and traditions and traditional medicine. And what does it mean to threaten very specifically and explicitly another person's life with medicine? What does that mean about you and your standing in the community, and you as a parent and you as a male, right? You can tell the expert that's one of the issues that I'm going to be talking to you about, or there's going to be some issues about where the kids are safest and who's the best parent. So I'm going to talk to you about, Child Protective Services got a hold of the kids from the McDonald's incident, but then, there's all these other factors like Marcy doesn't even really speak American Sign Language. Mom had to just make up a language, and dad doesn't even speak it. So you want to talk about that expert witness, right? You want to ask the expert, like, hey, when you get on the stand, is there something that's going to help you testify really, really well in the case? Like, would you like a power and control wheel? I like to do that. I've testified as an expert witness, and sometimes I get nervous, but if I have the power and control wheel, then I just like use that as a device to just like go around. Oh yeah, financial abuse. He doesn't let her have access to any of the bank accounts, right? Blow it up really, really big, put it up on a board. Sometimes you might, if you're one of those fancy courtrooms like they have at Yawkey with like everybody's got like a computer screen, you can put that up, right? You don't have to necessarily print it out on an old cardboard thing and like prop it up, right? But if they've got any charts or diagrams that they're going to rely on, say, hey, can I have a copy of that? I'm going to disclose that to the other side, and we're going to bring copies to court. And you want to get a really good CV or resume on them, right? Because you're going to disclose that to the other side. And you're also going to use that when you're trying to qualify them, which is building them up so that they look like the bomb, totally believable. They're going to help you, judge, to figure out what is the right thing to do in this case. If you can do a dry run and be like, look, I'm going to pretend I'm putting you on the stand. You want to see how it's going to go? Do a dry run. Okay, so not with all your witnesses, but it's okay if your expert witness looks a little bit, formal and rehearsed. That's cool. Okay. So when the expert witness comes to court, they should have several copies of their CV or their resume. And if you've given them a subpoena issue and they've got a subpoena duces tecum, then they need to bring in any of the documents that you've listed. Any of the information that they relied upon in forming their opinions. So if you gave them police reports or a copy of the McDonald's video, right, they should have a list of it or copies of it, and they should be able to say that I relied upon these things. They were provided to me by Shirley's attorney, and I reviewed them. If you can come up with a cheat sheet of like, Sarah Deer articles or like whoever else is like the acknowledged experts on domestic violence and sexual assault in Indian country in Alaska, right? A list of 4, 5, 10 of the articles that all of us know about, right? The congressional findings in the new Violence Against Women Act, those kinds of things, right? Little one-page list of things that you use in your everyday life, right? And have your expert witness bring that with her, right? Do not have her bring any confidential victim information. Okay, so don't supply your expert witness with a copy of like Shirley's sexually transmitted infection report that she's got herpes or something like that. That's not part of the facts, but like if something like that you don't want anyone to know, be careful what you give the expert, because that whole stack that she relies on, the judge can see it. If you're in a criminal case, the jury could see it, the opposing client can see it, and his attorney, right? So don't give them confidential information. I always tell my expert, try to speak like a normal human being and don't speak like you got a yardstick up your buttocks, right? Don't be like, I'm all that in a bag of chips and I'm smarter than you. Your job as an expert witness is to elucidate and inform and explain, right? And the emphasis is on Shirley and the evidence that tends to indicate that she was a victim of domestic violence, that she was not the predominant aggressor, and that she's the better parent. Even though she might look like she's poor on paper, she is the actual parent, right? And the focus should be on that and explaining it on the judge. Although you can, throw in some things to make yourself look a little bit, make her look a little bit smarter, okay? The expert witness, like all witnesses, are going to be sworn in. Sometimes that happens on the witness stand, in front of the witness stand. They can swear or affirm on a Bible, not on a Bible, right? But this is going to be all of your witnesses, including your expert, your proposed expert. And right, you've disclosed them, you provided information to them. They have a list of all the information that they relied upon that you gave them, and then maybe several articles that they routinely use that address domestic violence against American Indian, Alaska Native women, right? They've got all of that there. They got a copy of their subpoena, a couple copies of their CV. They got this right there in front of them. You can stand up and say, I'm going to, I'd like to propose this person as an expert on domestic violence, and I'd like to have them questioned, right? The judge can ask the other side, are you willing to stipulate, which means agree to the expert's qualification and allow them, right, to testify as an expert? And there's different reasons why they might do that. The main reason is that, Elsie or Clarice is so beloved that if they put her on the stand and then they try to tear her down, then they look like a class A jerko, right? And it prejudices the judge or the jury against, Marvin and their attorney. So if you've got somebody who's like unassailable, like universally beloved, you get them to testify as an expert witness. A lot of the times the other side will just stipulate, right? And you don't have to put them on the stand on direct, right? So you say, I'd like to propose this person as an expert witness. The judge will say to the other side, will you stipulate as the witness's qualifications? If they say no, they say yes, woo, you're golden, right? They can get on the stand and testify. If they say no, then you've got the burden. You put them on the stand, and on direct, you have to ask them about their qualifications, pump them up, make it look like they really are an expert, right? So that the judge will rule that they are an expert and they're allowed to testify, right? Now, once you do the direct on them, the other side is allowed to, may I voir dire the witness? That means they're allowed to go up there and try to like poke holes in that person's qualifications and be like, heck no, they're not no expert. They ain't no expert, right? Or either they're not an expert or they have bias or there's something wrong with this person. Do not let them testify as an expert witness, judge, right? So you, first of all, you go, you propose that witness as an expert, and you find out if you can get a stipulation to agree to their qualifications. If not, you're gonna have to put them on the stand and qualify them. The other side has an opportunity to poke holes in that and ask to voir dire the witness, which is going up to them and then trying to like challenge them on their qualifications, right? So no way, you do not have greater knowledge than the average layperson about violence against American Indian, Alaska Native women, right? And then they go and to me, it always feels like horribly insult your expert witness on the stand. Now, if you're trying to like knock out somebody else's like father's rights, fake expert witness kind of a person, by all means, go nuclear and try to destroy that witness. It always feels a little bit when the opposing counsel gets all nuts on it. To me, it feels like it might prejudice their side, right? So if I'm in a position where I want to knock down the other person's proposed expert witness, I try to do it in a classy, intellectual way and not be too emotional about it. Once the judge determines that the witness can testify as an expert witness, we are off to the races. And You can put them on the stand on direct and ask them all kinds of questions about the case, including what they think about the ultimate issue, such as who should get custody, right? That's what we're here for in this divorce case. Who should get the custody, right? Primary issue. They can weigh in on it, and an expert's testimony can have a lot of weight with the judge. Okay, you're going to put the expert witness on the stand. You're going to elicit testimony from them in a narrative form using who, what, where, when, why, open-ended questions. You're not going to lead. You're going to be logical, linear. It's going to flow beautifully. They are going to have relied upon a packet of information that you gave them, likely never having met your victim. And they're going to explain the information through their lens as an expert on domestic violence against Native women who've worked in the field for a long time. And they're going to explain to the judge, what does this mean, right? What does this mean? Why might have Shirley thrown those rocks at the truck as Marvin was leaving? You know, was she committing acts of domestic violence? Was she the predominant aggressor, right? Kind of like break it down for judges, right? So that the judge can understand what's happening, right? They're the explainer in chief. Who, what, when, where, how, why, right? No leading, only open-ended, right? Remember those dance moves, right? And that's why practicing in advance with your witness can be helpful. So you can be like, hey, once you get qualified, I'm going to start asking you about all your qualifications, right? We're going to go there. And so I want you just to be like, you know, what kind of expertise do you have in the area of domestic violence? And then I just want you to just go. If you want just talk for 3-4 minutes about how wonderful and all the stuff you've done, I'll applaud that. Okay. So you practicing in advance can help with this dance move. So you want to bolster the witness. You want the judge to be like, I am the luckiest person in the world that I have this incredibly smart person here who's going to just digest all this information and tell me what it means, right? So your witness should dress professionally, act professionally, not talk the way that I've been talking during this whole video, right? All casual, right? They have to act like somebody who is serious, has serious knowledge about domestic and sexual violence in Indian country and has worked in the field and understands what the literature is and understands the dynamics in your community, okay? Now, when I've got an expert witness, I don't just give them all the positive stuff. You got to give them the dirt too. You want to let them know like, hey, Marvin is going to talk about Shirley being arrested for the trophy throwing incident. So we're going to have to explain that to the judge, right? Because a lot of judges, they might not understand, right? They just think like, these two, they just go at it all the time. I can't tell which one. We'll just split the baby in half and give them each half, right? So be prepared to draw the string. Tell that the sting. So tell the expert witness about anything that is like maybe not such a beautiful fact, right? So that they can address that when they're on the stand. When they're finished doing their direct examination with you, so you're asking them about their credentials, you're asking them about what they relied upon in forming their opinion. You're asking them to analyze certain facts and issues in the case. And then you're asking them like, you know, the ultimate issue. Who do you believe should get custody of the children and why, right? And then hopefully you just blown the judge away. They absolutely are in love with the expert witness. You've got them on your side, right? Now, the other side gets to voir dire or cross-examine the witness on their qualifications. Normally what they're going to be crossing them on or voir diring them on is like, you're a hired gun. You got per diem and you got to stay at the casino and you got mileage to come and they give you $100 and you make your money on this and right. Sometimes they're going to just be fixated. Now, like in like a DUI case and stuff like that, they have like experts on DUI when you're doing criminal defense for people who get caught drunk driving, that, you know, it could be $10,000 for your expert. So whenever you've got a drunk driving case where they bring an expert witness on, you know, the other side, the prosecution is going to be like, how much do you get paid? What percentage of your income do you make testifying as so-called expert, right? Trying to show that their bias is that they just are prostituting themselves for money, right? They can also be, they can infer and ask questions that you know, this is somebody who, you only testify for women because you're a man-hating lesbian who just, right, always the men are bad and you always like the women and never testified on behalf of a male victim. Those are pretty much the main things that they're going to try to go after your expert on is you're biased because you're getting a bunch of money. And then also you're like a man hater. You don't, you know, women's always right kind of thing. There's other field, you know, areas that they can try to attack, but those are the two. Usually on the credentials, if it's on domestic violence and it's in tribal court and you've got a tribal citizen or somebody from another neighboring tribe who's got pretty good credentials, that's not going to happen. But I have seen people go to the mat and get ugly in state court and in federal court in some important cases with expert witnesses about their credentials, right? Probably not going to happen to you, but be prepared for that, okay? Another thing that they can do, your expert witness, is they can just be like all like, oh yeah, they're starting out all casual, and then they'll start to be like, you know, it's not math, but like, what's the square root hypotenuse of 3? You know, like ask them super technical questions like, you know, please define these terms. What is a predominant aggressor, right? Or I'd like you to speak to Lenore Walker's cycle of violence and its acceptability today. You know, like they'll just like, they could. So cycle of violence, I've heard people be cross-examined about that, and you're supposed to say, no, that was a theory in the 80s, and the current theory that's most widely accepted is power control based on the Duluth model, blah, 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 right? Sometimes they'll give you a hypothetical, like, you know, what if the moon was made of Swiss cheese and Shirley sprouted wings, then would it have been different at McDonald's? Or they give you some kind of facts that are slightly different. Right? They're allowed to do that. You can't do that with a regular witness, but with an expert witness, the other side's able to do that, give them hypotheticals. So you might want to warn your first-time expert about that. And then they get to ask them, you know, what documents that they relied upon. So if you don't only give your expert witness the documents that are favorable to your client, if there's other stuff that, you know the other side's going to bring out, right? So maybe it's the report that the children were like, their hair was unbrushed and they weren't showering and that kind of stuff, right? Give them the good, the bad, and the ugly, but don't give them the confidential, right? Because sometimes they're going to try to go after your witness in there. Now, sometimes you're going to offer up a expert witness and the judge is going to say, will you stipulate to the other side? And they'll say yes. And then you'll do the happy dance. Sometimes the judge will say, will you stipulate? And they'll say no. And then you go and you put the witness on the stand and then you try to qualify them on direct. Sometimes, and don't let this freak you out, it'll be the other side's turn. The judge will say, would you like an opportunity to voir dire the witness? It's pronounced a bunch of different ways. People in Oklahoma pronounce it all kinds of crazy ways, right? They can be like, no, I'm good, right? And then you're like all shocked, right? Why do they do that? Well, if it's like Clarice and she's like, you know, the most beloved person in the entire world, they don't want to be a jerk. They want to look like they're classy, like, oh yeah, we just want to make sure everyone's, you know, following the rules, wanted to make sure that you qualified them, you know, that's cool, we can keep going. If your expert witness's testimony didn't hurt them that much, they can just be like, we cool, no problem, no questions needed, right? And then the judge can rule that they're allowed to testify as an expert, okay? Or maybe they have their own witness. This is not very common that you're gonna have an expert witness and they're gonna be like, oh no, beloved Clarice, who's in her 80s that everybody loves, she stinks. We've got Fred, my neighbor Fred's gonna testify. That doesn't happen that much, right? Just know that it's a possibility. Also the judge, when the witness is on the stand and you're like asking them about the qualifications, judges are allowed to ask questions too. First time when I was a young lawyer that happened, it like shocked me because I wasn't prepared for the judge to ask questions. I'm like, no, wait, hold on. I asked the questions and direct, and then they do cross. Why is the judge asking questions? Now, I got to let you know that in some jurisdictions in criminal cases, such as Arizona, the jury can ask questions. Boy, that's a mind blower. You get your whole case set up in your mind, how I'm going to say this, and I'm going to anticipate Marvin's defense on that. And then you got to deal with like questions from the judge and jury. So that can happen too. Know what your jurisdiction allows, right? if the judge feels like you should do redirect or recross, he or she will allow you to do it. Generally, redirect is only if you need to clarify things that were raised on cross. Okay. After the expert witness testifies, the judge can say, I'm keeping you under oath and you need to remain in the courtroom, or you can remain outside the courtroom, or I'm releasing you. If they release the witness, that means, go back to your house or your office and have a beautiful life. They can also, in many cases, just, sit in the back and just observe the trial if they want to. Now, drum roll, haha, I'm so tricky, because the whole purpose of this entire lecture is to trick you into the fact that yes, you can qualify as an expert witness. I'm telling you folks, the facts that you're in this course means that you are the bomb. You have great education, specialized knowledge, right, and experience on domestic violence against American and Alaska Native women. I bet my boots, I'll bet some nice boots too, some Lucchese's, that you're going to be able to testify as an expert witness on domestic violence and or sexual assault in tribal courts, right? And now I'm going to go through the nuts and bolts about how yes, you can testify as an expert witness on DV. And once again, you're not testifying for your own client that you've been a victim advocate for, or that you're a legal advocate for, but somebody else's client, ideally somebody that you've never met, and you're just being handed some documents that you review, and then you apply your knowledge and expertise, right, to the facts to be able to go through them and come up with your opinion. So we're going to talk about you. Yes, you as an expert witness. And I tell you that any single one of you in this course, I would put on the stand in tribal, state, or federal court to testify as an expert witness on behalf of a victim of domestic violence. I would. You're that good, right? Because you do, say it out loud, you have greater knowledge than the average layperson, right? So if you're just like at the Quickie Mart gas station and you just like pull over a regular person, I can almost guarantee you that you have much, much greater knowledge, experience, right, than they do in domestic violence, and can explain it to the judge. So this week's assignment, and I'm going to be talking about it, is I need you to have a current resume or CV. Now, do as I say and not as I do, because mine is embarrassingly old and funky, and I got lazy, and it's very bad. So don't do what I do, right? Don't do that. You want to have a current resume or CV that is really, really expansive. Okay, and that CV or resume is going to be provided to the other side. So make it look nice, right? And that CV or resume can be admitted, as part of as evidence in the trial and as part of the official trial transcript. So you want to make sure that you're not doing any glaring spelling errors. So maybe do a little spell check on it. You want to list your name and all of your qualifications. Now, I don't think it's like really matters if your name is, if you're known as Fuzz, and that's what everybody knows you as, and you put like quotation marks right there, especially if you're testifying in your own community. I don't think nicknames are bad. If you're trying to be all fancy in federal court, if you've got a funny nickname, maybe you might want to not put that on your resume. But if it's like, anything that you're commonly known for, I would say that's fine to do that along with your titles and your address. And remember, if you're at a shelter or someplace confidential, don't use your physical address. And if they ask you about it on the stand, where are you physically located, you could say, it's a confidential, undisclosed location. My mailing address is whatever, PO Box XYZ, right? Recommend that you not use your home address. It's going to be a part of the official record, unless maybe you're in a small community and everyone knows where you live anyways. You want your contact information. I don't know if people are using fax numbers anymore. We still have one. You can include that. All of your education and your work experience. And that includes education at the National Tribal Trial College, y'all. You're going to have 2 certificates from there, right? Including an advanced certificate. So please list that as part of your education, right? And your certificates. any training that you've attended. So a lot of us go to, the US DOJ Office on Violence Against Women tribal consultation, or we're going to the Crimes Against Women conference in Dallas, like, right? All of those trainings that you go to, or you're going to CPR training, right? You want to list on your CV or resume, or your expert witness wants to list it, every training that you go to. So stick them all in a drawer, and then every couple of months or once a year, go through and make sure that you update your CV or resume. Or don't be ADHD like me. Be logical and linear and organized. And as soon as you get done with your webinar, go in and type it onto your CV or resume, right? Including the name of the presentation and where it took place. And if you've got the name of the presenter, right? And the date. Your employer, full name of your employer and your job title and a synopsis of your job duties, and include, relevant previous employment. You can put in your volunteer activities, right? So if you volunteer to take in animals while victims are in shelter, or using a hotel motel voucher, right? And that's related to your work. Or maybe you do art therapy with trauma survivors, something like that. Feel free to list it. Also, if you're like sitting on these committees, which I know you all are, where you're like talking about what are your protocols for Indian Health Service? Should they be forced to like screen every victim for domestic violence and sexual assault or not, right? Or you're revamping your code or your forms, right? You want to put that in your CV or your resume. If you're a member of your state coalition, right, you want to list that, or any professional organizations. I have a note saying be mindful. Like if you're right, like some places, I'm in Arizona, member of the ARA and the NRA, people would be like, woo, love ya, right? Right. But if you're living in a different kind of a neighborhood, people would be like looking at you askance, right? So be mindful about what you list on your CV or your resume for your professional associations or memberships. Sit in any committees. If you're on the board of directors of any place, Boys and Girls Club, you sit on your state, national, tribal task force. Anytime that you provided training anywhere for any reason, I don't care if it's like the middle school health class, Chamber of Commerce, make sure that you list that, right? If you're delivering fancy lectures at national conferences, right? Keep a copy of the date, the title, who where it was delivered at, the name of the conference, those kinds of things, and keep a copy of your written materials if you can. Anything that you write that gets published, I don't care if it's in the tribal newsletter, if it's in the National Tribal Trial College newsletter that we send to you electronically, right? You can list that. Anytime that you're on the radio or TV, right? You want to list that. If you are an expert on domestic and or sexual violence against American Indian or Alaskan Native women, then you should do your cultural competency skills should be listed. So if you speak the language, you participate, you're the head woman for the ceremony, you're enrolled, you're a veteran who's been honorably discharged, you've won, some big bomb award for how fantastic you are. You want to list that on your CV. Now, this one is interesting. Once you qualify as an expert witness, and I'm pretty certain that you all will, if you want to qualify as an expert witness, and if I ever have a case, I would use any single one of you to do it, right? And you qualify, and the judge gives you the blessing, yes, you are qualified, you can testify as an expert witness in this case, and then, continue your questioning, and they ask you questions about who gets custody, and what's your thoughts about escalating violence and kicking people and almost having miscarriages, right? Whatever they're going to ask you about, right? And you get to qualify as an expert witness. Well, what you're going to do is you're going to keep a list of every single time that you testified as an expert witness because you qualified. So I've given an example, Tana Atam Nation Tribal Court or Pima County Superior Court, United States Federal Court for the District of Arizona, right? The date of your testimony, what the caption of the case is, so state of Arizona versus Marvin Walker, right? Or it was a civil case. You testified as Shirley's expert witness in the protection order that Marvin filed against her, right? So you want to have the caption of the case, the date of your testimony, what court you were in, which party called you to testify, and the type of case that you testified in. And here's a couple of examples. So on April 5th, 2013, I testified in Hopi Tribal Court as an expert witness in a protection order hearing, and I was called as an expert witness and qualified by the victim in the case, who was the plaintiff, right? So that would be an example. And you can list this on your resume. Don't be like Hallie. Make sure your resume and CV are updated, right? Don't just think I'll shove them all in a drawer and then review my calendar at the end of the year and I'm sure I'll capture it all. Don't do that. Don't do that at all. Make sure it's not bragging, just get it all down there, because by you so-called bragging on all the great stuff that you have, you are going to be possibly saving somebody's life and their children's lives, okay? So maintain a current list of all of your publications that you've done, all of the times that you've presented, all the times you've qualified as an expert witness, your education, the trainings that you've attended, right? Once again, wow, how many times can I say this during this presentation? Don't provide direct advocacy for the victim if you will be testifying as an expert on her behalf. And I can tell you that expert witness testimony, that you'll either be putting your own expert witness on to help your clients in your cases, or you, yes, you can qualify and testify as an expert witness in tribal, state, and federal courts on domestic violence and or sexual violence against American Indian and Alaska Native women. And you will help the trier of fact to understand facts and issues in the case, and you will increase safety, justice, and healing for Native women and children. And that is why we are here, folks, in this course. You are much loved. I can't wait to see you. I'm excited about getting to see you and spend time with you. And I hope that this week is excellent for you. And thanks for hanging in here with me, folks. I'll talk to you next week.